will know the difference.
Yeah, right. Right.
Hey, good afternoon, everyone. Hi, my name is Greg Butler. I am the Executive Director for Local Government Academy. Thanks for joining us on this Tuesday afternoon. Today we have a class for you called Regulation of Wireless Facilities by Local Governments with the Cohen Law Group and Mr. Dan Cohen, who will be stepping up here in just a second. Before we get started, I want to just cover a few things and, as usual, promote some of our future classes in case you're interested. Little housekeeping, we're still using YouTube Live, so that just limits our chat functionality just a little bit. So if you have any questions during Dan's presentation, just email me at gButler@localgovernmentacademy.org. I will be right at the computer receiving those questions, and I will bring those back to the studio for Dan to answer. So please, if you don't mind doing that, if you have a question anytime during the presentation, and I will make sure you get that question answered. Quickly, Local Government Academy. Many of you are familiar with us, but if you're not, we are a nonprofit, nonpartisan, and non-advocating organization that primarily provides education to local elected and appointed officials. We also have internships in the summer throughout several municipalities, throughout several counties. Those are currently going on, so hi interns again if you're on. I'm glad you're watching. We also provide technical assistance to Act 47 and EIP communities and provide grants when funding is available. In order, we have a few classes lined up that are great. These are mostly all webinars and mostly all free. In fact, every class I'm going to present is free of charge. We have a coordinating road construction and repair with utilities in collaboration with Sustainable Community Development Network and Connect and PA One Call or Pennsylvania 811. They're going to cover a new software application, cloud application, that is available to municipalities and utilities to coordinate road construction and utility repairs so that we're not doing the same work twice. Very new, and it's very effective, and they want to show that to you so that you can start to use it and avoid extra costs of redoing work. We also have a human resources class called Things I Wish I Had Known About Labor Law When I Started Out, and this is with Campbell Durant, Beatty, Palumbo, and Miller. And it's a fairly fundamental session about general HR issues that you should be looking out for and making sure you handle correctly, so you don't have to hire a lawyer like Dan Cohen. Little joke, he's standing right there. We also have our what I think is a blast. It's our annual recognition luncheon, and this is available if you are willing to pay $35 for a great lunch. It's at the Engineer Society, and this is our chance to celebrate all the folks that have helped us throughout the year, all the volunteers, instructors, supporters, financial supporters. So it's a really nice event, great networking opportunity. Just thought I would throw that into the presentation in case you're interested. You're able to go to our website and register through the website and pay online if you are interested in going. Also with Cohen Law Group, they're going to come back. I think Dan is going to do this himself on Wednesday, September 12th for an hour. He's going to talk about negotiating cable franchise services with confidence. So it's a discussion about what to come to the table, the information to come to the table with whenever you meet with your cable provider to talk about available services and strategies for cost reduction. So that'll be a really good one. Also with Gateway Engineers, we have a general strategic class about road maintenance and long-term budgeting. And the idea behind this one is as the winter season comes, ways to start analyzing roads and start planning for spring paving and summer paving for 2019. So Gateway is going to tell us different ways to identify stresses in roads and different ways to repair that don't cost a lot of money. And then this one I threw in, it's not completely finalized, but it is a Beaver County Economic Development Symposium. That's actually probably not even the real name, but it's a collaboration with Washington and Jefferson College and Local Government Academy. We're going we're going to have an in-person session where we're going to have several speakers talking about the cracker plant that's being built there and the economic impact it may have on the area once it's completed or even during construction. Behind this discussion is a long-term study from Louisiana, I believe, where there is an existing plant and all the good things that have happened to that community since that plant has been built. So more on that through our social media and website and future webinars. But it is set for Tuesday, September 18th, and it is free. With that said, thank you for listening. I would like to present Dan Cohen from Cohen Law Group, and he will introduce himself. Thank you.
Thanks, Greg.
Thank you, Dan.
Good afternoon, everyone. My name is Dan Cohen, and it's my pleasure to be here to talk about wireless facilities regulation. Let me first just thank Greg and also Justin on the technical side for putting together this webinar, and also for all the great things that Local Government Academy does. Local Government Academy really does a great job in informing municipal officials about issues that are important to local government, and that's fantastic. So one of those issues important to local government is wireless facilities regulation. I also want to have a special shout out to the Beaver County COG. Apparently the COG is kind of having a lunch and learn today on this subject, so thanks so much to you for taking the time for this webinar, and also for everybody else who is joining in as well. So let's dive right in. How we doing?
Should be good.
Oh, great. Okay, that's me. All right, so let me just give a brief overview as to what we're going to cover in this webinar. We're going to first give a little background on the demand for wireless broadband. Then what are the new wireless facilities that are being rolled out to meet this demand? And they are brand new. It's not kind of the traditional cell towers that you've seen in the past. What's the impact of them on your municipalities? And obviously, since we're a law firm, what are your legal rights? What are your current legal rights under federal and state law? And how should you prepare yourself, particularly through a wireless facilities ordinance, to be able to address these new facilities, to protect your municipality, and also raise, be able to assess fees on them as well. I also want to talk about at the end some threats to municipal rights that are occurring at the state level, because those are serious threats and really would be helpful if all of you were part of the municipal mobilization process to try to get rid of these threats. Okay, but let's start with Janet Swenson. That's Janet Swenson there in that photograph. Janet is a citizen in Northampton Township in Bucks County. I got to meet her and know her fairly well through a wireless issue that occurred in Northampton Township. So here's what happened. Janet got up one morning, she had her coffee, she opened the door to get the newspaper that morning, and lo and behold, she sees two men in her front lawn. One who is painting a white, with spray paint, a white circle at the edge of her front lawn, and another guy with a 25-foot fiberglass pole. And I don't know if you can read the sign that Janet is holding right there, but what the sign says is, do you know that a 25-foot tower is going to be erected on this corner? So the Northampton Township supervisors, by the way, Janet was not alone. There were about 20 of these towers that were going up. And in that particular area, it was a residential subdivision where all utilities were underground. So these towers were a particular eyesore there. Northampton Township ended up in 2 lawsuits over this because these towers were really not permitted under Northampton Township Code, although the code wasn't particularly up to date because it really referred back to some conventional towers, but luckily there was language that we could use, and it was a mess, frankly, a mess that we'd rather you not have to be involved in. So, and we certainly, if you have any questions, we can talk about, how the Northampton Township case was resolved. It basically was settled out of court. The towers were redesigned and taken out of the neighborhood, the key neighborhood areas. But again, it took a lot of attorney's fees, it took a lot of time and effort, and there's a way to avoid that, and I'm going to tell you how. But let's first talk about why is it that those workers were on Janet Swenson's front lawn. And really, it all comes down to this, right? Your smartphones and your digital tablets. So the way that wireless data is measured is through exabytes, right? And don't worry, we're not going to get too bogged down in this, but just to give you an idea. So wireless traffic in North America, and by the way, an exabyte is a billion gigabytes, for those of you who are into that, but global traffic in North America in 2016 was 1.8 exabytes per month, okay? By 2022, as you can see, it's expected to increase to 10.8 exabytes per month. So in other words, wireless traffic, wireless communications throughout North America will increase, if my math is right, by about 6 times between 2016 and 2022. You can see the number of U.S. subscribers that have wireless connections increased by 52%, right, from 2009 to 2016. I keep this last one in the PowerPoint just because, even though it's a little bit dated, it's from the period from 2007 to 2012, but the number is so incredible that I keep it in, and that is not a typo. AT&T alone experienced 20,000% wireless data increase in that 5-year period. Okay, so what are the facilities that are being used to be able to support this traffic? When I say traffic, I mean this wireless communications, right? So as you can see, there are megacells, macrocells, microcells, picocells. Megacells are the traditional cell towers, right? Those are the towers that you either have in your community or probably close to your community that provides phone coverage. And the large towers have a coverage area in miles, right? Macrocells, and that's really what we're going to be focusing on in this webinar, are smaller towers and antennae that have a much smaller coverage area. It's about really 0.2 to a mile, but the majority of them are about 0.2 to 0.4 miles in coverage. Microcells, those are much smaller antennas that cover a even smaller area, and picocells really are more for indoor. But as I said, we're going to be focusing mostly on macrocells. Okay, so what are the big changes that have occurred since traditional cell towers? Well, it's really summarized in this slide, and that is that new wireless facilities are, although smaller, not necessarily small, much more targeted, much more numerous than traditional cell towers. And here's the big game changer, okay, is that they are being installed in the public rights of way, right? The public rights of way that you control as a municipal official, as a public trust. And the PUC grants these, we're calling them wireless contractors, certificates of public convenience. In other words, utility certificates that give them the right to enter the rights of way, although under the reasonable regulations of the municipality, it also gives them eminent domain power. So those are the two big game changers. Well, say 3 big game changers that have occurred over the last 7 or 8 years. One, there are new kinds of towers that are much more numerous, smaller, and used to boost capacity. We'll get to that in a second. 2, they're in the public rights of way. That really hasn't happened up until a few years ago. And 3, the PUC is giving them utility status. Okay, so what do these things look like? And the fancy name for them is Distributed Antenna Systems, or DAS. And this is an example of what a DAS tower looks like. We're going to kind of break down that tower in a moment, but it always kind of surprises me that the woman standing there is smiling because you probably wouldn't want a tower like that in front of your house, but that's what one of the towers looks like. And let me talk a little bit about why these towers are being placed in the public rights of way. The purpose of them is not to expand coverage, because traditional cell towers already have that coverage. But that coverage really is only for phone service, right? So, and obviously these smartphones are used for much more than that. They're used for internet applications, often downloading not only of Google searches, but also downloading of video streaming, right? And that requires a lot more bandwidth. And that's what DAS, or distributed antenna systems, are for, to boost capacity to allow more rapid download of these internet applications. Now, who are the companies that are doing it? Well, I want you to draw a distinction in your mind between a wireless carrier and a wireless contractor. Okay, a wireless carrier, there are 4 of them now. There probably will only be 3 soon, because 2 of them are merging. But Verizon, AT&T, Sprint, and T-Mobile. Sprint and T-Mobile are trying to merge. Those are household names. You know them very well. The contractors that are going to come to your municipality, and by the way, it's not an if, it's a when, will have names that you may or may not be familiar with. Names like Crown Castle. Crown Castle is actually a company that started in Pittsburgh. They're now a multi-billion-dollar company that basically builds towers and DAS systems. Mobility has a funny spelling there, as you can see, but they're a contractor for Sprint. ATC, or American Tower Company, that's a company that went to Northampton Township. New Path, those are the names that are most typically seen for DAS applications, for DAS facilities in municipalities. Now, look at this next bullet point, if you would, because this gives you an idea of the tsunami that is coming, a huge wave of these towers, okay? So between 100 and 150,000 DAS and small cell facilities have been constructed. By the end of this year, between 100 and 150,000 of them have been constructed nationwide, okay? Now, this is from S&P Global Market Intelligence. By the end of 2026, 800,000 of them will be built. So that is almost an 8 times increase of the number of these DAS towers and antennas that are going to be placed around the country, including, believe me, in Western Pennsylvania. Okay, that's another image of a DAS facility in the row, and when we say row, of course, we mean rights of way. That's a bucket truck that's working on one of them. Okay, so as I said a minute ago, let's break down what a DAS tower, what the components are of a DAS tower. And this is more a legal webinar, not an engineering webinar, but at least it'll give you an idea. The node for this tower is really the tower itself plus the antenna, right? There are a lot of other things that are on that tower in a control box, and you can see right there what those are. The antennas are typically 4 to 5 feet tall. They're usually, although not always, cylindrical antennas. Now, but they're going on top of towers, either existing utility poles, which occurs in many cases, or if there aren't utility poles in the specific place that the wireless contractor needs, then they'll put up new fiberglass poles, and they can be anywhere from 25 to 120 feet tall. So Janet Swenson back there in Northampton Township, when she said 25-foot tower, she was actually lucky. Mobility, which I mentioned before, a contractor for Sprint, they will put up 120-foot towers in the public rights of way. And often in residential neighborhoods, unless you kind of step in, and we'll talk about that in a moment. Okay, so there's the node. Then there's fiber that goes from the node back to a hub site. The kind of the misnomer about a wireless system is that 80% of a wireless system is wired right? So it's certainly the node collects a wireless signal, converts it to an electronic impulse, and then carries that impulse through fiber that goes through your community. And obviously that is a wired portion of the DAS system. And it goes back to a hub site, which is a building that houses the routers and switches and other equipment. Okay, so that's what a DAS tower, what their tower components are. What's the impact of these? What would be, if you haven't experienced them already, or what is the impact, if you already have experienced them, of these wireless facilities on your municipality? Well, look, it creates a physical impact on the public rights of way. Those rights of way are a very narrow ribbon of real estate on both sides of streets and roads. And as you well know, because you're dealing with it every day, there are lots of companies that are trying to get into that narrow ribbon of real estate, right? Electric company, gas company, telephone company, water company, fiber companies, internet service providers, wireless companies. So it's a, it's a struggle, and it can be a mess. And so adding these new wireless facilities to the rights of way can create certainly a physical impact. It has a financial burden as well, right? Because, from the person at the desk, at the permit desk, who provides these permits or has to review wireless applications, or in some cases getting an engineer or a lawyer to review the wireless applications to see whether it's consistent with state and federal law or whether it's consistent with engineering standards. That all costs money, obviously. So it creates that burden as well. And then finally, there are aesthetic issues, right? Most people don't want a new 120-foot fiberglass pole to be placed right in front of their house. So, as I said, these are very different from traditional cell towers. And what I recommend, and our law firm recommends, and gosh, I think we've worked with now 150 municipalities on these, is to take a proactive approach and to develop a regulatory structure that really protects your municipality. Make sure that you are reimbursed expenses on the financial burden that these pose, and strikes a balance between the need for wireless broadband on the one hand, because for many communities, particularly more rural communities, wireless broadband is not easily available right now. So there is a need for it. In urban or suburban communities, generally, wireless broadband is more accessible. But the need for wireless broadband on the one hand, and to preserve the character of your community on the other. And you can do that. Well, let's talk about how you can do that, and let's talk about what are your legal rights when it comes to these facilities, right? And this sentence right here really sums up what your legal rights are. We're going to get into some more details, particularly details that have been established by the Federal Communications Commission, or the FCC. That's who's in charge of this. In addition to your municipality, it's really two governmental authorities that are in charge of this, the FCC and your municipality. The PUC, by and large, does not regulate these things. Okay, so the 96 Telecom reserves your local zoning authority over them, particularly over the placement, construction, and modification of those facilities. So that is a critical point, that this should go in your zoning code, not in your street and sidewalks ordinance, not in a right-of-way ordinance. It needs to go in your zoning code, because that's where federal law gives you the authority to be able to regulate these facilities. Okay. So let's get into some of the details when it comes to what your legal rights are. They're usually it's really a list of don'ts. Okay, so you can't regulate wireless facilities for health effects, sometimes referred to environmental effects of radio frequency emissions. I can guarantee you that if a new tower or set of towers is being planned for your municipality, one or more citizens will come up and talk about the health effects of these facilities, and they may be right. There are studies on both sides of this issue as to whether they call, X township or X borough do not have the legal right to regulate the health effects of these facilities. Okay, we already said number 2, the second bullet point there, you can't prohibit or have the effect of prohibiting. It's worth repeating. So if you want to say, well, I'll just keep all these wireless facilities out of my township or borough, you can't do that. You have to instead regulate them in a more prudent manner. You can't discriminate against different providers. So for example, if Sprint wants to put a tower on Main Street and then Verizon a year later wants to put a similar tower either on Main Street or another rights of way, you can't treat Sprint differently from Verizon. You have to treat them essentially the same. Doesn't have to be exactly the same, but essentially the same. That's common sense. You have to act on a request within a reasonable time, and we're going to put a pin in that because we're going to get to what the FCC has said are reasonable times. And of course, if you deny a wireless tower, then it has to be in writing and supported by substantial evidence. Okay. All right. So what's a reasonable time according to the FCC? Now, you and I may not think it's a reasonable time. And by the way, both the state and federal governments are trying to shorten these time frames. But here's the law today. And it comes from the FCC's, what was called its shot clock order of 2009. And it's pretty simple. 150 days for towers, 90 days for antennas. Okay, so what does that mean? When does the clock start and when does it end? Well, the clock starts when a wireless contractor submits an application for a tower or an antenna in the public rights of way. So you'll hear from, as I said, Crown Castle or Mobility, bounce that application and say, it's either not complete, we need these more materials, more information, or in many cases, you didn't submit it to the right department. You submitted it, say, to Public Works or Engineering, when in fact you should have submitted it to zoning. So you have 30 days to do that. If you don't do that within 30 days, then the application is deemed completed. And if your municipality doesn't act on the application within 90 days for an antenna or within 150 days for a tower, then it can be deemed approved. Now, there are a lot of cases where the municipality and the company work together and they go past those time frames by agreeing in writing that they can do that. But that's not a sure thing. So you want to make sure that if there isn't an agreement to extend that time period, that action is taken within those time frames. Okay. Okay, that's really the major part of that slide I wanted to talk about was the time frames. There are many other federal orders on wireless regulation. I just want to mention a couple of them, and there's also one Pennsylvania law that you need to know about. So the Spectrum Act was passed in 2012. That was actually a congressional act, and it would take a lot more time than we have today to go through the details of that act. But the crux of it was, if a request to change a tower or to change an antenna is such that it doesn't substantially change its physical size, then it has to be an approval of right. Basically, all you have is a building permit, right? And substantially change is defined in a pretty, in not the clearest way, but basically, if it increases the size of the tower by 10%, less than 10%, then that's not a substantial change, and therefore you have to approve it with a building permit. If it's more than 10%, again, an existing tower that's being changed, then you have all your zoning rights that we talked about before. And the Pennsylvania legislature kind of enacted that into state law at the end of 2012, called the Wireless Broadband Collocation Act. Okay. The FCC also had a 2014 order. It was like a 150-page order, but it was somewhat helpful for municipalities because It reiterated that zoning is the way to go with siting wireless facilities, and that DAS poles can be viewed as being towers, right? That was pretty important. Now, there aren't that many judicial cases in this area because DAS is brand new, but in the few that have been decided, and it's mostly on the West Coast, where the wireless company is pushing for kind of right-of-way authority to get in the rights-of-way, and the municipality is pushing for zoning authority to be able to site these things in a way that's compatible with the community, municipalities have won. Okay, so what's the recommendation for your municipality, if you haven't gone through this process already, is pretty simple, but pretty important, and that is to draft a new ordinance or amend your current cell tower ordinance to, as you can see, achieve the following things. One is address these new facilities, because most likely your ordinance comes from the late 90s, right after the 96 Telecom Act. We've seen hundreds of these, and they do not address facilities in the rights-of-way because they didn't exist, right? Incorporate recent regulatory changes in federal and state law. Include separate requirements for towers and antennas, that's important, and separate requirements for wireless facilities that are both inside and outside the public rights-of-way. And finally, and this is an important issue obviously for all municipalities because you have so many unfunded mandates, right, is to be able to collect reasonable fees for facilities in the rights-of-way. So let's talk about that. You can assess fees on DAS facilities and others in the public rights-of-way. In Pennsylvania, we're a cost-based, for a cable franchise agreement, you can charge up to 5% of the cable operator's gross revenues for cable services. Here, in the wireless arena and anything really in the rights-of-way other than cable, the things like reviewing the application, going through the approval process, traffic management when these things are being installed, inspections as time goes by. Those are some of the basic costs that this would be referring to, and your fees would relate to what those costs are. So in most cases, you would have a wireless ordinance that addresses these. And then when each individual company comes, you'd have a separate short form lease for each of those companies, and wireless contractors will, at least as of now, will negotiate pretty generous lease payments to be able to place those facilities in your public rights-of-way. Now, if you own the poles, which certainly there are some municipalities in Pennsylvania that do, or if it's a street light that you own, then significantly higher fees are available. Okay, so what's the bottom line? It is to take your old cell tower ordinance, right? Dust it off and convert it to a comprehensive wireless facilities ordinance that does all the things that are in this paragraph here. Truly protects your residents. And by the way, let me complete this thought first, and then talk a little bit more about protecting your residents. Protects your residents, addresses these new technologies, allows for the collection of fees, incorporates recent regulatory changes like we just went through, and strikes a balance between the need for wireless broadband and the character of your community. Okay, let me just kind of go off text for a moment here and talk about how it is that you protect your residents, because ideally you'd like these towers to be in areas that are not residential areas, right? So when you do the wireless ordinance, and as I said, we've worked with many municipalities on these ordinances, and every one of them is different because every community is different. Every community has its own topography, has its own zoning approval processes. Some do things by special exception, some by conditional use, etc. One of the big issues will be, well, where do we want these things to go? And as long as you don't prohibit or have the effect of prohibiting them, you can say where they should go. And often it comes down to the streets and roads in your community that make the most sense, and particularly what are called the arterial roads, right? The major roads, as opposed to some of the smaller residential roads. So it's a process for doing a wireless facilities ordinance that works for your community and also is consistent with the law, but it's a really important process. Okay, let's step back for just a few minutes and talk about what's happening at the state level when it comes to wireless regulation. And honestly, this is an area where things happen at the state level very quickly. Not necessarily changes in the law, but certainly changes in bills and changes in judicial decisions. So let's start actually with the courts. And some of you may have been involved in this. The PUC back in 2017, so just last year, decided that wireless facilities are not public utilities, right? Particularly DAS type facilities are not public utilities. On June 7th of this year, which really was just a little over a month ago, by the way, that decision was challenged by Crown Castle. It's called Crown Castle versus PUC. The many municipalities and the statewide municipal associations submitted amicus briefs, friends of the court briefs, to uphold, asking the court to uphold the PUC. Unfortunately, the court did not. The Commonwealth Court held that DAS contractors are in fact public utilities. What it really does, it maintains the status quo. That had been the practice of the PUC for 10 years prior. In fact, that was a big element of the Commonwealth Court decision, which is, you've been doing this for 10 years, you shouldn't be changing it. We respectfully disagree, but the Commonwealth Court obviously has the power to do that. It doesn't look like it's going to be appealed to the Supreme Court. So as of today, and I don't see this changing, DAS companies like Crown Castle and the others are public utilities under the Public Utility Code. Okay, let's move from the courts to the Pennsylvania General Assembly. About a year ago, 7 state legislators introduced House Bill 1620. Now, House Bill 1620, in a nutshell, would undo pretty much everything that I talked about in this webinar. And what it would do is it would gut municipal rights when it comes to being able to regulate wireless facilities, right? Now, how would it do that? Well, specifically, it would abolish municipal zoning over wireless antennas in the row, in other words, in the rights of way. In other words, you can't have any authority over them whatsoever. And it would nearly abolish your authority over towers in the rights of way. And that's probably the more damaging part of House Bill 1620, because antennas are certainly less obtrusive than towers are. But House Bill 1620 would effectively abolish your rights over towers as well. It would preempt municipal authority over those. It would exclude the public from the approval process, because there is no approval process. It would severely limit the assessment of fees. House Bill 1620 is very confusing on the fee side. There are literally 5 different provisions about fees in the bill. But really what it comes down to is that you could charge the most minimal fees, maybe $25 for a wireless antenna and $50 for a wireless tower, and that's it. Obviously this bill was written by the wireless industry. They don't want to have to pay out fees, so therefore just write a bill that says you don't have to. Now, in terms of the process, what House Bill 1620 would do, it would allow a company to submit up to 50 permit requests in one application. And then remember earlier I talked about a 30-day period for reviewing that application? Well, guess what? Under House Bill 1620, it would reduce that to 10 days for the initial review of the application to see whether it's complete and any other materials are needed. So it increases the number of actual applications can be filed under the guise of a single application, and reduces the time period for the initial review of those applications. Clearly something that is not in the municipality's best interest. It would take away your right to include standard legal protections from wireless companies, and honestly, these are in every kind of document related to the rights of way, and frankly, every kind of document that your municipality has when it comes to physical facilities, right? Certainly in your cable franchise agreements, and that includes insurance coverage, bonding, indemnification. House Bill 1620 expressly says you can't have any of those. And this is one that hits close to the heart because we work very closely with solicitors on these issues. It would expose outside solicitors and kind of special counsel to solicitors to financial liability of $10,000 per occurrence for drafting an ordinance that they deem to be in violation of House Bill 1620. So as you can see, it is very damaging to municipal interests and to municipal rights. And for that reason, all of the statewide municipal associations have opposed it. So whether you're a member of PSATS or the Pennsylvania Municipal League or Boroughs Association or the Township Commissioner Association, all of them have sent letters of opposition. We drafted those letters. Hundreds of city councils and, as you can see, township boards and borough councils have passed resolutions opposing them. It looks at the moment as if House Bill 1620 is not moving, basically on life supports, but it's not dead yet. So you really need to stay informed about this because, look at wireless, your rights over wireless facilities is one thing. Your rights over the rights of way in general is another thing. And if the General Assembly undermines your zoning authority over wireless facilities, then other portions of your zoning code would be the next to fall, right? And if the legislature eliminates your power to regulate wireless towers and antennas in the rights of way, then they could take away your powers over all facilities in the rights of way, and that really would severely damage your ability to manage your community. That's really what all of this is about. So there is a rumor, I think it's a pretty strong rumor, that because of municipal response to House Bill 1620, which has been fantastic, that the wireless industry is drafting another bill for introduction in the House soon. I'm guessing it'll be really within the next couple of weeks. Apparently, Representative Frank Ferry is the sponsor of the bill. So what I end with here is that there are really important principles, and these are principles that I had the opportunity to convey to the chief lobbyist for Verizon, and hopefully we'll have the opportunity to convey to the state representatives and potentially state senators who have to vote on this. Is pretty simple. One, the municipal position is preserve local zoning authority over wireless facilities in the rights of way. That's the authority by which we can protect our community. Two, allow for reasonable consideration of these applications. Don't shorten those timeframes because those shot clock timeframes are pretty short as they are. Encourage co-location, meaning encourage antennas to be placed on existing poles, even if it's another company's pole, rather than building new towers. Allow us to charge fair and reasonable fees. That's, again, common sense. At least allow us to recover our costs and let municipalities do their jobs. That's really what this is all about. And I really thank you very much for listening in, and would be happy to take any questions that you may have.
Thank you, Dan.
Do we have any questions?
So far, there are no questions.
Okay.
I'm sorry, I put out a last-minute request.
No problem at all.
There were any. Checking my phone.
Well,
there's still time if you have questions.
Let me say this. my name, phone number, and email are up on the board right now. If you have any questions or any concerns, please just get in touch with me. The other thing that we do as a law firm is we do a free legal assessment of your current ordinance, whether it's a cell tower ordinance or a wireless ordinance. It truly is free, and you don't have to hire us. And what we do is we review it. We see whether it is adequate to meet the needs that I outlined in this webinar, and we'll tell you if it is. Great. If not, we'll give you some recommendations as to what you need to do, and we're happy to do that.
Okay, currently still no questions.
Okay.
I'm sorry.
No problem.
I'll just quickly say thank you, Dan.
Thank you.
Looking forward to having you back for the cable franchise class in September. I'll check one more time. I don't want to cut anybody off. Looks like we're done. No questions.
Thank you so much. Appreciate it.